Well, it's got to be frustrating if you're a college student and you've been given a task of writing an essay, and so you do what every college student reasonably does. You sit down at your computer, you pull up the topic, and you immediately ask AI to write an essay for you. Then you turn your essay in, which of course AI did on your behalf, and the teacher comes back and says, "This has been copied. This is plagiarism." And you say, "How could it possibly be plagiarism? I didn't even write it." Sure, it's a problem. John Risby is the patent professor and is adjunct professor of patent law at Nova Southeastern Law School in Florida. He's written a couple of books on patents. And John, boy, I'm just thinking about those college sophomores who might be getting booted all because when they cheated the wrong way. John, there's got to be something to protect these people.
Yeah, well, I don't know if there's a right way to cheat, but certainly the using ChatGPT or AI is problematic. I mean, teachers don't know what to do. Professors don't know what to do. As an adjunct professor of patent law, when I was in law school, we had paper exams and blue books, and you would be given a pen and paper, and that's how you would do the assignments. It's a different world, and it's really hard to prevent someone from using AI to create a paper or a test or whatever. But the issue from an infringement, from an economic standpoint, becomes one of damages, right? So in the business world, it's not just plagiarism and getting a lower grade. Now it's damages for infringement, and there's been a lot of talk about Google offering to defend people that use AI from claims of infringement, and I think it's problematic because it's a promise to defend, but there's a lot of fine print that I don't think a lot of people are paying attention to.
So, John, help me understand the scenario in which this might happen. So, tell me if this would fall into that category. So, I'm a company and I make widgets, and I'm trying to come up with a description of my product. So I say, AI, give me a description of my product that does this, 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 and this. And then AI kicks back a brief description, right? Or, maybe it's an elevator pitch kind of thing that you might put on your about page or something of that sort. And then come to find out, maybe AI has pulled something from the internet that is copyrighted, given it to you. You've published it thinking that this has been generated on your behalf, only to find out that you've infringed on someone else's work. Does that fall into the parameters? Am I following this correctly?
You are, okay. And there's two different issues. The first one is who is the author of that piece of work, and that gets down to the constitutional basis for intellectual property is that there's a human author, right? And this goes back to the original Supreme Court case about photography. And the question was, is the camera the author or the human being? And in that case, the court held that there's enough creativity by the human operating the camera, and the camera is just a tool. And the difficulty with AI is that those supporters of AI who claim that the human is still the author claim that the computer or the AI is just a tool, no different than the old cameras or a painter's paintbrush or a sculptor's chisel. But the reality is that technology is a whole lot different than a painter's paintbrush. You simply can go to some of these programs for creating art and put in a simple prompt, and that's all you have to do. It takes 15 seconds, 20 seconds to enter the prompt. You get back a beautiful piece of artwork. It's one hell of a tool, right? It's a lot more. It's not a paintbrush anymore. It's like basically doing the artwork for you, and that's where the problem comes in. Is if there's not any editing or any revisions or any human input or control, then the human is not the author, and you can't get copyright protection on it. So that's one issue. The other issue is an infringement issue. Who is doing the infringing? If you use Google Bard or ChatGPT to have something written, are you the infringer? or is Google responsible, or ChatGPT responsible? What's creating an uproar is kind of a lot of interest. Is Google stepped forward, kind of in a way to get more people to utilize their AI tools, and said that if you're sued for copyright infringement, Google will take on the burden of the defense.
But as you mentioned, John, there's a lot of small print, a lot of fine print on that. So, I mean, how might you get screwed on this if you think, oh, no, I used Bard and there was a copyright infringement. Oh, I don't have to worry about it because Google said they'd back me in court if it came to that. But you're saying there's a lot of fine print. What do I need to look out for?
So the fine print, the problem is, like, all of us are overwhelmed by terms of service agreements anytime they use an app or anything. I mean, you buy a 99-cent app on from the for your iPhone from the App Store. There's 50 pages of fine print terms of service for that. And someone did a study that if you really were to read all of the agreements, the terms of service for everything you use, that's about 6 hours a week just in reading all your agreements. And then you finally agree to the thing. You say you're one of those that read the 50 pages. I'm a lawyer, and I haven't, I got to be honest, I haven't read all of those. Then you get these notices that says, whatever, Facebook or has updated their terms of service, agree, and you have to scroll past 40 pages and hit agree. You're kind of stuck. What do you do? Like, you've got all your pictures, your contacts, you've got everything in this app. You either agree and you get to use it, or it's all gone. So there certainly is a need for legislation that creates some minimum level of protection for consumers, that not every contract that you agree to should be enforceable. So that's one issue. Google's got terms of service that put all sorts of burdens on the user. And the biggest loophole is that Bard is not included in the protections against copyright infringement. They exclude Bard. So a lot of people assume that, okay, Google's doing this, they're going to cover me if I get sued for copyright infringement. But the asterisk or the footnote says Bard's not included. It's almost like those. It's kind of like warranty claims, right? Like they're only as good as the company that stands behind them. There's some, for example, like that are just unrealistic. They'll say if your shoes are worn on anything other than carpeting, you can't return. There's not, but who does that? Like, walk across the room and carpet on your shoes in order to return them. Apple's got all kinds of loopholes, right? If there's any proof, any evidence of water damage, I think they put litmus paper or something inside their iPhones, and if there's water damage, then it voids the warranty. A lot of car warranties, if you don't get a lot of dealer warranties, if you don't get your oil changes from the dealer, they're not going to enforce the warranty. So until the courts really test and we have some evidence of how Google's going to be held accountable for their claim of don't worry. It's almost like, don't worry, the water's fine. We've got floaties for everybody. Come on in. That's great until someone drowns and we find out, all right, you know what? Those floaties didn't work. So it's untested right now.
They were unfloaty floaties. John, I got to bounce here. John Rizvi is the patent professor, adjunct professor of patent law, Nova Southeastern Law School in Florida. He's written 2 books on patents, and I guess the moral of the story is buyer beware. We need some more protections, and the fine print is probably going to exonerate everyone from what they said they were going to do in the first place. John, I love having you on, man. Thank you so much. You really elevate the intelligence of the program. Thank you, sir.